Okay, perfect. Thank you. 11:03. Yeah, I think this is perfect timing. Welcome everyone. Again, thanks for being so timely and for your interest in this topic. Today, over the next couple hours, we're going to be doing a deep dive into legal considerations of our statewide CPACE program here in Virginia. I'm Bettina Burgu, for those of you who I don't know, which I think is most of you. I'm the Energy Efficiency and Financing Programs Manager here at the Virginia Department of Energy. We go by Virginia Energy. For anyone who's not active in Virginia all the time, we used to be the DMME, but now we go by Virginia Energy. So we are hosting this today along with our CPACE Program Administrator, Virginia PACE Authority. I know a lot of you know them very well, so I'm kind of the new kid on the block, but really happy to be part of the effort and to be working with them, as well as the team at Slipstream that's going to be providing technical assistance for the program, the statewide program. I also see a couple of my colleagues here from Virginia Energy are here, especially Al Christopher. He's the director of our Renewable Energy and Energy Efficiency Division at the agency and has been a champion of the statewide CPACE program for a long time. So I just want to acknowledge him and say thank you for that. So the objective for today, we are hopefully, today is going to move us closer to, I would say, finally finalizing and rolling out the statewide CPACE program for Virginia. We have some statutory requirements that are part of our program structure, but we do have a number of key decisions that we have to make as we finalize the core program documents. So we are really looking forward to getting your input on those decision points. In terms of housekeeping, hopefully everybody heard that we're recording. That's just for our future reference, but if anybody wants the recording, we can send that to you afterward. Just let me know. And we do literally want to hear from you. We have, this is going to be a discussion, but since we do have a little bit of a sizable group, I think the way that we would love to do the discussion is for people to put your name in the chat. And then someone from the VPA team will call on you, and then we'll go in individual by individual to make verbal comments. You can also put comments in the chat. Anything substantive that's in there, we will also be following that and take that into consideration. I think that's it on housekeeping. Okay, so agenda for today, a little bit of background on the statewide program, refresher for folks. Again, intro to VPA, who I don't know needs an introduction with this group, as well as a general overview of kind of the status of CPACE in Virginia at the moment. But most of the time is going to be discussion of first, like I said, those high priority topics that really are those decision points that we need to make decisions on. Open discussion for anything that we haven't gotten to yet, and then we'll talk about next steps. So again, just as a refresher for anyone, our Code of Virginia does authorize localities to enact CPACE ordinances, and there are a number of local programs already existing, which we're going to talk a little bit more about later in the current status overview. And then in 2020, the General Assembly authorized Virginia Energy. Ooh,
sorry, I had a little problem there. Sorry about that.
No worries. In 2020, Virginia Energy was authorized to establish a statewide CPACE program option for localities. So last year, in 2021, Virginia Energy went through a competitive procurement process through which we selected VPA with technical supports from Slipstream to design and administer our program. So super happy to be at that point, finally. And then I think the next one, Nakia, you're going to say just a little bit about VPA.
Yes, hello. Again, I'm Nakia Fisher, and I'm with Virginia PACE Authority, and I work in operations. Virginia PACE Authority has been around since 2019, a 501c3 nonprofit organization put together by our director, Abby Johnson, who we have here. We also have Ellen Dixon on the call, who also works in outreach with us. And then we have Slipstream, We have Holly Ettinger, excuse me. She's also on the call. And Bill Nussbaum, who's also on our board. And we began promoting CPACE legislatively since 2014 with outreach and education since 2015. We now have 10 under contract. I'm sorry, 9 under contract. The 10th will be in January 2022. The 5 programs in Loudoun, Fairfax, Alexandria, and Norfolk. Sorry, I'm gonna let someone in here. And Dumfries. And then we have soft open programs for Roanoke, Fredericksburg, Louisa, and Winchester County. I'm sorry, the city of Winchester.
Fantastic, thank you. So just to wrap up this kind of background section, like I said, we of course have the state law governing CPACE in Virginia. So there are elements of the program design that are set by the statute. I'm not going to go through all of these. I think a lot of you are already familiar with them, but I'll point out just a couple things that are maybe interesting because they aren't in place in all states. Namely, on the first bullet, new construction is eligible. We have in our statute resiliency and stormwater management. Added somewhat recently, loans may refinance eligible improvements. I think that's all I'll mention on this slide. And then just jumping down to the third bullet here, our state statute says that the CPACE lien may be enforceable by local government in the same manner as a property tax lien. That's a little bit of a harbinger for discussion to come. And then also the ordinance on the local level must include a draft contract, also known as the program agreement, that specify the terms and conditions of the loans. So that's also something that we're going to be coming back to in this discussion. Abby, over to you.
Okay, great. And thanks everyone for joining. I really appreciate your interest in our program. And I know many of you have been involved in one way or another for a number of years. So I'm sure you all are also excited about the ability to have a state program that will make it easier for everyone to participate. So far, we have 16 localities that have passed ordinances, which represents nearly half of the state. That's primarily because we have most of the Northern Virginia jurisdictions enabled, as well as Norfolk and Eastern Virginia. We also have Roanoke and a few others kind of in Central Virginia. I would say that, you know, we foresee a lot more, we see a lot of interest from localities. So I think that already we're going to get, you know, more folks on board, but I think with the statewide, it's going to be, we're seeing really a ramp up so that when you look at how you look at the state, you'll have a really good chunk of the state that will be enabled by 2022 for your projects. Also, I wanted to point out that most of our programs and that ordinances and therefore the programs have really been within the last few years. So some of you who've been around a while may know we did start back and, you know, getting the critical amendment in 2015, but really it's only been since, you know, end of 2019 that we've had, you know, more than one program open in the state, and you know, then we had COVID. So I really think that 2022 is the year to really watch for the state. Also, I want to point out that we do have a direct bill opportunity for capital providers, which is allowed by an AG opinion, which is utilized by the majority of jurisdictions that currently have ordinances or programs. Also, I want to just point out generally, and many of you already know this, is that we are a pretty strict Dillon rule state. And I'm not an attorney, but I will tell you that I've learned a lot about the Dillon rule over the last 4 or 5 years, and specifically that if you want major or important items incorporated in a PACE program, you have to have it in the state statute. So we have gone back so far 4 times and potentially a 5th time this year to make tweaks to really make this a really rock solid statute. So keep that in mind when we talk about the legal documents and the ordinances and how all of it fits together. It really starts from the state statute. And similar to most states, we do enable the program through an ordinance passed by cities and counties. And also in the case of the town of Dumfries, incorporated towns. Also, I just wanted to say that, we certainly have, legal agreements already in place, which I'll show in a few minutes, that lay out the remedies and responsibilities of the parties per the statute, but also in practice, we're seeing that you have an ordinance and a financing agreement that has to be put in place. The way the financing agreement, what it is exactly is up for interpretation. Most localities have gone with some type of tri-party agreement between the borrower, capital provider, and the local government. And basically the way it works is that the statute allows for the local government to assign an individual in staff to be the point person and the decision maker for the PACE loan. Therefore, we do not require a vote at the local level. This, at least, is how it's been interpreted by all localities to date. That basically, probably the head of the department typically will agree to sign off on the PACE loan, which is good. Some states aren't like that. So this I don't expect you to read. It's obviously it's in your packet that we included of different documents we already have in the existing program. It's just to show you that, one, how important the statewide program is, because it will over time eliminate some of these differences. They're not extreme. This is kind of my cheat sheet in case someone asks, and I send it around to capital providers when they ask for it. But there are some differences, and it's in there to just, have you be aware of it, because you may say, oh, I really like the way Loudoun does it, or I really like the way Norfolk does it. And those nuances you can capture and understand by looking at a matrix like this. This is just a snapshot of the existing documents that are either complete or in process. So we've already done, obviously we can receive PACE loans. We have received PACE loans. We've underwritten PACE loans. So we do have the documentation there. We have a few that we haven't need to use yet, 7 and 8 in particular, that are under contract currently, and hopefully will be, for the statewide we anticipate will be approved, by the end of March. So, we could talk, I feel, for a long time about many, many aspects of the program. And it's impossible with this many people on the phone or the Zoom, and impossible to really dig down to every specific issue. So certainly we are going to give an opportunity to, of course, place your comments in the chat. You can certainly email us at info@virginiapace.com, or my personal email at abby@virginiapace.com. Certainly we're going to open it up for discussion, but we really wanted to, let you know some things that have been on our mind, and also, hear from you. So we're leaving a lot of time at the end, as Bettina alluded to before, to really open up the discussion. So this is meant to be pretty interactive after we finish this kind of overall description to you all. So I'll go with the first topic, which is just the approach of the program agreement. So currently we have two types of program structures in terms of the tri-party or program agreement. It's called program agreement in almost everywhere in Virginia, but it's basically the tri-party between the capital provider, borrower, and the local government. And the approach used by the Loudoun, Fairfax, et cetera, you can see in approach 1, basically there's a pretty brief, both of them have pretty brief ordinances, both types, but their program agreements vary in depth because of what they're accomplishing. So in approach 1, basically we're anticipating that this is a pretty short agreement, tri-party agreement, that really doesn't have the particulars of the loan terms between the borrower and the capital provider in them. So there's a separate financing agreement or loan agreement that would be executed by those parties. And that's something that has to, of course, not conflict with the tri-party, but it's something that is not necessarily part of it can be modified per the capital provider and borrower's needs. In approach 2, you have one document that contains, which is a tri-party, but contains also the terms of the loan and some of those particulars between the borrower and the capital provider. And that is in the 4 localities you see below, Fredericksburg, Lynchburg, Roanoke, and Petersburg. So we have 2 different ways that the jurisdictions are approaching this. And what we're trying to do is really just have one I think that we can't, maybe there's a complexity level that could be altered, which I'll talk about later. But I think in terms of, we don't really want to have legal, lenders, PACE capital providers, and others have to dig into two types if possible. So that's one thing we've kind of run into as this program's unfolded, because as a local program, there's no kind of state set of documents that we can refer to when we talk to a locality. So here are some questions, and then after I finish reading the questions, I'm going to open it up for you all to speak. Now, I will let you know that because I'm presenting right now, I cannot see anyone unmuting for the moment. So I'm going to let Nikki or Bettina handle that process. So I'm going to read the first question, then I'm going to pause and let you all handle anyone who wants to unmute, or we can read from the chat. So the first question is, do you, in your capacity as a capital provider, a local government, potential borrower, borrower's representative, or anyone interested in PACE, frankly, in Virginia, do you prefer one approach in terms of the design of the tri-party over another? And if you do prefer one, can you please tell us why? So I'm going to pause and let the team unmute one of you, whoever wants to go first. And if there's no comment, I'll keep going. But
yes,
David,
I'm sorry, David Sykes has a question.
Okay, please. Hi, David.
Well, I had a clarifying question based on the documents that were on the box site. In the slide, it seemed to indicate that the financing agreement wouldn't be a tri-party agreement and the program agreement would, but the documents that were on the site, it has 2 3-party agreements.
So it's there's the one that's the Loudon one, and that has a short tri-party, anticipating there'll be a separate agreement, which we haven't included, that is executed by the borrower and capital provider. The other type is the one from Roanoke, and that basically anticipates everything in one document, one big.
I see.
Program. Thank you for asking that question, and I'm sorry that wasn't clear. Do you have any opinion on that, David, since you were unmuted?
Well, yeah, I think I also looked at the documents that were on the Arlington site. It's to me, it seems like the less involvement in the in sort of the commercial terms on the program side, the better, and the shorter the documents, the better.
The only thing I'd say about Arlington is they don't have the local government. Arlington's not signing anything, so it's not a tri-party.
Don't they sign the certificate of levy?
Yeah, I'm not sure if they do. I mean, I don't want to get all political here, but from a Virginia standpoint, but basically, they're not agreeing to enforce the lien. And as far as, unless they've changed it, they were not a party to the agreement with the borrower and the capital provider. I don't think it's like Illinois where you have 2 bilateral. That's not my
right. I saw they have a bilateral agreement, but then they have what I would call a Connecticut style certificate of levy and an assignment of assessment lien. Either way, I think that having the program sort of need to review and be involved in all of the commercial terms that the capital providers would be concerned with seems like a wasted opportunity instead of and resources, because you're reviewing a lot of provisions that frankly probably wouldn't be important to you and are important to capital providers. So giving them the flexibility to have that agreement look the way that they would like and have the terms that they would like and language that they would like, to me seems like a preferable way of moving forward.
Okay, thanks a lot. Appreciate that. Anyone else? Again, I can't see, so I'll let
David Schaefer.
Hey, David.
Yeah, hi.
How are you?
Thanks. Yeah, so my sort of teeing off a little bit where David Sykes was going is why presume there needs to be even a tri-party agreement from the outset? The statute doesn't require that. and it does in places, distinguish between the lien and the loan agreement. So if you were to use, for example, traditional, commercial, lending, there's a loan agreement and a note, and then there's the mortgage. And the mortgage is the lien. In PACE, the lien document, whether you call it an assessment contract or something else, is between the municipality and the borrower, and that can be standardized and formalized to contain only the most basic terms necessary to establish the lien terms, and then every other economic term between the property owner and the capital provider could be set forth, in another agreement, and the municipality doesn't need to be a party to that. And the principal reason for my suggestion to sort of follow that model here is, just streamlining the process. The more verbiage and text you put in front of a local government official, no matter how much you try to streamline things, the more you invite delays and uncertainty into execution of the process. Only the county can establish the lien, and therefore you could take your simple tri-party agreement, make it even simpler, make it a single, two-party document between the property owner and the county, continue to reference that additional terms will be provided, in a financing agreement between the capital provider and the property owner. And that will take the county out of things that it is really not necessary for it to pass upon, because it has a program administrator who's going to verify that the property owner is eligible, the improvements and so on and so forth. So my suggestion is not to just assume that we have to go with a tri-party agreement route and come up with a simpler process to execute.
Thank you, David. And I'm not. It's more like this is what's been happening, and so obviously, if we went with what you're suggesting, which I completely see a lot of the benefits to, it would just, we'd have to think about how that would work for the existing localities. But I think what you're saying, I just want to confirm, is that agreement, that bilateral agreement, would be between the local government and the borrower, because
Sure.
I think, right, okay, because that's not my understanding. Arlington is between, it's like a loan doc. It doesn't include the county. So this would, or the city. So this would be, and you would foresee, I'm assuming, a separate bilateral agreement, which would happen anyway between the borrower and the capital provider as well.
Yeah.
Okay.
I mean, other than recording a document which says, okay, there's a lien, the lien is for, X dollars over a Y term, cross-references a financing agreement. And, basically the purpose of recording the lien is to provide, constructive notice to other third parties that there is a lien on the property that is senior to mortgages and other private debt in pari passu. And if some third-party creditor has an interest in understanding what the underlying terms of that lien are, they contact the property owner and say, "Hey, what's up?" And they can provide the agreement or not.
Hey, I'm up for simplification and making this easier to streamline, because we all know after years of being in this industry that there's PACE is not. It's not simple for to get through the gate. So if we can make it more streamlined, that's very helpful. Thank you, David, for those comments.
Sure.
And
Thank you.
I appreciate that. I've known you a long time. So anyone else have anything to unmute? And then after that, I think Ellen will read any chat comments.
Yeah, Bill, I'll read the chat comments. But Bill,
Okay.
yeah, Bill.
Yes, thank you.
Hey.
I just wanted to add my 2 cents that in favor of a shorter program agreement. I hadn't really considered the perspective that David Schaefer it put out, but as far as a tri-party agreement is concerned, I think the Loudon example is for all the reasons that Teresa Fontana elaborated on a moment ago in the chat, is the more desirable route to go, with the shorter, more succinct sort of pro forma agreement and relegate as much as of the deal terms as appropriate to a bilateral loan agreement between the capital provider and the property owner.
Thanks, Bill. And Bill, by the way, is a partner in Williams Mullen and out of Norfolk. So he's been working, and not only our board member, but also helped do, I guess, the template ordinance way back in 2016, 17, and been involved a long time in the development of the program. So he'll be involved in this process as well. So thank you, Bill, for those comments. Is there anyone else on the Zoom wants to unmute? And then I think, yeah.
So Abby, this is Andy.
Hey.
Hey, Andy, thank
Andy
you.
from Virginia Beach. And since I worked in local government, I want to second what David Schaefer said. When we get to talking about the enforcement process, that this partially relates to that, because if you have a 34-page document or something like the Roanoke one, and that's supposed to be used to enforce this lien, it's just a way too much legal review. Every possible detail can be part of a conflict. I really support the idea of keeping the documents that secure the lien separate from all the financing arrangements as much as possible, as was discussed. I think it would work better for everyone.
Thanks, Andy. And Andy, you were how many years with your head of the redevelopment agency, right, for the city of Virginia Beach?
So it was the City Department of Housing and Neighborhood Preservation for 28 years.
Yeah. And Andy is also working with us right now, actually. So thank you so much for joining and your comments.
Yes, we have Teresa Fontana.
Hey,
Hey, thank you for your comment. You want to add?
Sorry about that. I had to figure out how to unmute there.
Okay.
No, I don't really have any additions. I think, yeah, we believe the shorter the better. I think we just wanted to put enough in there to give the capital providers, enough assurance that we would enforce these loans, and then also whatever we felt was needed to, have the borrowers consent to put this voluntary lien against their assessment against their property, and then to leave the actual loan terms very flexible, because we did not want to try to dictate to capital providers, what their loan terms were going to be, because that would basically foreclose many, many loans, because a lot of that stuff is just not negotiable. So that was our thought.
Thank you.
Thank you. Next, we have Michael Yackey.
Hey, Abby.
Hey.
The only point I want to make is in line with what everyone else has been saying about simplification, is that I prefer bilateral agreements. On the other hand, what has to be present in any bilateral agreement is a supplemental document that clearly spells out the rights and relationships between the capital provider and the local government with regard to assignment, right to proceeds, all that kind of stuff. So I don't like tripartite agreements because it puts it all in one document and gets it all very complicated. And I like simpler, shorter documents, but you have to have if you're doing a bilateral agreement between the property owner and the local government, you have to have a strong separate document outlining the rights of the capital provider with regard to the assessment and the lien.
Absolutely. Great point, Michael. And thanks for joining us today.
And Andy Bridge. I want to emphasize what was just said. It's really important that the capital provider has their documents in line. I know in DC there's a tri-party agreement, but it's not entered into until after the financial agreements are set, and then it's added to those documents between the capital provider and and the borrower. So it's simpler, it's short, but it does give enough oomph into the what needs to be enforced as far as repayment and that kind of thing is concerned.
I'm sorry, I can't see anyone. Who was this, by the way?
Andy Bridge with Eagle Bank.
Oh, hey. Hi, Andy. I always
Hi,
like to say
Andy.
hi to my friends. I just can't see anyone right now. Nikki, anyone else want to unmute?
Yeah. And then we have Jessa Coleman. Hi, Jessa.
Hi, good morning, everyone. This is Jessica Coleman from Naveen Green Capital. So yeah, I have a few comments, a lot of which kind of piggyback on some of what's been said. Generally speaking, we are fine with a tri-party agreement, but what I will say is that between the Loudoun template that was shared and the Roanoke template that was shared, we would strongly prefer the Loudoun template, again, for the reasons that I think have been mostly shared so far, which is, we would prefer to have the flexibility as a capital provider. One thing that we do, that I'm sure a lot of our colleagues do as well, is we already have a template, financing agreement that, we go off of. So having to sort of convert to using a different financing agreement or those types of financing terms in a new market is just a little bit of an extra lift for us that I don't think is necessary. And then I would also point out, again, just sort of the flexibility. I think it was David who said it earlier, like some capital providers might prefer to have a note alongside a financing agreement. Some might just want one single document. So we tend to prefer to leave that particular aspect to the private markets. That's all.
Hey, Jessa, can I ask a follow-up question given our extensive, so know each other a long time and deal in multiple markets? I totally appreciate that you're saying that. It's obviously different than Maryland. So can you give us some insight of, because I think the other Roanoke version looks a little bit more like Maryland's. So I'm kind of curious of your opinion about that. If you think that is Maryland significantly different in the way it's structured than the Roanoke one, in your opinion? Or is it just the state and servicing is done by the counties? That makes it all very different in terms of what you need in the document.
Yeah, I mean, full disclosure for everyone on this call, I didn't get a chance to read the Roanoke one in depth yet. But I do think that there are still a lot of things in the Roanoke approach that are not included in the Maryland documents. So referring to more of the financial terms between the borrower and the lender, like, what's the advance schedule, and what's the construction schedule, what are the events of default, and like the environmental requirements of the financing. That is the stuff that we tend to keep out of that the Maryland program, I'm having to switch my head, keeps out of the statement of levy and lien of surcharge agreement, which is also a tri-party agreement. But I think the main difference is that that document that's used in Maryland focuses much more, although it is a longer document, I think in full it's still only kind of like 12 pages, right? And it focuses more narrowly on more of the servicing of the assessment. So it, places the surcharge, which is what they call assessments in Maryland, on the property, and defines how it's going to be billed and collected and enforced. And then the, payment schedule of the financing is attached to that agreement and recorded in the land records, but the full financing agreement is not attached as an exhibit to that agreement and is not recorded in the land records. So all of those other terms are left off of it.
That's right, because it's like a schedule with, it's like an exhibit within the main standard offer, which you do one time for capital provider. So that's a different kind of structure. So thank you for that, Tessa. That's very helpful. Yeah. Anyone else have any questions on this preference before I go to the next question? Someone let me know.
No more on this end.
It looks like Michael Yaki's got his hand raised again.
Okay.
I think that was earlier.
Is that earlier? Okay. Well, then I'll just move on to the next question. So basically, I think piggybacking on that approach, the next question says, one of the goals is to create legal documentation that fits the needs of different types of capital providers, borrowers, and local governments. And so the context of that is that, we're looking to really promote community banks, other kind of commercial banks be part of the program in addition to national capital providers. And with that, and I think, Harry from Atlantic Union was on the call earlier, for example, we want to make sure that whatever we come up with is going to be addressing maybe some little bit different needs or approach that they might have to other kinds of capital providers, for example, or if we have a very small project, do we need to have the same forms as we do for something that's like a $30 million project? So maybe having this kind of very simplified bilateral agreement would solve that question, but that was based on thinking is there a way to try to, you have Michigan has the kind of the small business, the small loan program and the regular loan program for PACE. Is there something we should do in a similar fashion on the legal documentation side? That was the context of this question, which may have been answered by everyone's comments, but I'll put it out there if anyone has additional comments to that. Anyone else? I think is Cliff on the call? I'd like to sit his standpoint if he's on the call. I can't see.
Abby, it's Bill
Okay.
Nussbaum
Okay.
here. Yeah, my thinking is that it falls into the category of walk before you run, and the launch of the statewide program is going to be complex enough as is if you're not launching two programs essentially for big deals and a separate program for little deals or smaller deals. I think that can certainly be a goal to aspire to as VPA gets its feet under it as the statewide program administrator, and we also see where the demand is. I think it may be important to aspire to that in terms of our commitment to DEI in the program, to the extent that becomes, that we see that diverse borrowers may tend towards smaller loans, potentially. So it's a ball we need to keep our eye on, but I'm not sure how practical it is to try and roll out both programs at the outset.
Just to be clear, I wasn't referring necessarily to the program itself, but just if there was a streamlined document, but it sounds like we're kind of moving that way anyway. So, but I appreciate the aspirational comments because I think it's going to be important that we address smaller projects that nationally are just, it's really hard to get them financed right now because of just the complexities of PACE. So thank you, Bill.
We do have Ali Neary who would like to ask a question. Oh, no, I'm sorry, you did answer hers.
Ollie has something to say.
Hey, thanks for pulling this all together. I think, I definitely understand that a lot of properties will need, smaller balance PACE loans, and to the extent that national PACE capital providers won't fund some of the smaller deals, we need to get other folks involved. Honestly, I think it might just have to be one like someone was saying earlier, we roll out the program, we have the documents, and then whatever community bank steps up to the plate for whatever small balance loan has to take the sort of legal hit of helping you come up with streamlined small balance documents, and just sort of like letting somebody be the guinea pig, and then you have your small balance set of documents.
And Bala, can you give us some context why you know a lot about this, please?
I mean, so when I used to run the Michigan program, the statute allows for different requirements for smaller balance loans. And so we were working with folks to come up with like a PACE Express type program for the smaller balance loans. But honestly, the biggest issue with the smaller balance loans is a lot of the fees are still so heavy that, if somebody needs a $100,000 PACE loan and the fees are like 20 grand, then it's like, is it really worth paying a 25% markup on your money in order to get it? Sometimes it is. Sometimes people are like, well, I need the money for 20 years, so I'll suck it up. But for other folks, they're like, this doesn't make sense, and then they find other ways to finance. But the option definitely needs to be there.
Yeah, understood. And this is a little off the discussion, but I think we still have plenty of time. Do you think, Bali, do you have any ideas about how one would reduce those fees? Are you just referring to legal fees, or just generally like the audit fees, other stuff? I mean, did you have any thoughts on that?
So for the smaller projects, the audit requirement were to be less, that would be helpful, just because the more strict the energy audit, the more costs. Or even having certain things that just automatically qualify and don't require an audit, that would be helpful. The legal fees are sort of fixed. A lot of law firms have a bit of a minimum, so it's not like you can get the legal done for $100. But to the extent that the documents are pretty form, then that decreases those fees. If those banks charge a smaller origination fee and things like that, then anything to just drive the closing costs down for the smaller balance loans would be beneficial to those taking out those loans.
Thanks, Bali. Absolutely. I noticed that Kelly had she disagreed with what Jessa said. That's Kelly from Twain Financial. Is there anyone else who wants to add to either what Bali said or just generally before we move on to the next topic? Okay, well, now I don't see anything more in the chat, and I'm going to assume from the silence we can move on. So excitement, let's talk about lien enforcement in a PACE program, specifically Virginia. So in most ordinances that we have in Virginia, there is the option to enforce from the local government in the ordinances of the local government, as well as in the program agreements. Usually, or in some instances, I should say, not all, in some programs, there's the option of assigning the PACE lien to the PACE capital provider. So mainly what I want to make sure that's done, and I'm not an attorney, I was thinking earlier today that a lot of the program administrators actually are attorneys. So maybe, there's an additional perspective they may have from years working in commercial real estate law. But just from being in the program and talking to capital providers, borrowers, and localities, I just want to make sure that whatever process we have for enforcement, it's really clear. I feel like that's something that could be improved in our program docs, or at least there must be a process by which those who are not in Virginia, don't understand, foreclosure law in our state, would be able to understand relatively easily how it works. And I would say, like cities and counties have different foreclosure process timelines, and that's something that may not be the case in other states. So that's just kind of the perspective that, we certainly want there to be enforcement. We think that's a key, component of PACE. It's not required in the state statute, but most localities are certainly saying that they will do it unless a capital provider wants to do it instead. So with that, I wanted to just kind of, I don't know how many, maybe not everyone had time to read through the different sections. So I'm just going to, for like a few minutes, I'll actually just read it out loud, and then I have my questions. So in the state code, this is what it says: that the C-PACE lien may be enforceable by the local government in the same manner that a property tax lien against real property may be enforced by the local government. The local government shall be entitled to recover costs and expenses, including attorney fees, in a suit to collect a delinquent installment of an assessment in the same manner as a delinquent property tax. And that also includes interest and penalties for delinquent installments that can be collected in the same manner as property taxes. So that's what it says in the state statute. So it's not shall, you don't have to do it, and that's why a few localities have not. But generally, the localities have agreed to understanding the importance from the perspective of securitization and making this financing available, that's an important provision. I do certainly want to ask later on whether there are differing opinions about that. But let me go to the next section, just again for context for those who may want a refresher on what some of the information is in the program guide. So this is from the Loudoun ordinance, just to give the context then from the program agreement. The ordinance of Loudoun says that pretty much the same thing. The county shall enforce, so it says shall instead of may, the lien and all the delinquent penalties in the same manner as a property tax. It also allows for the county to assign the lien to the capital provider by executing a C-PACE lien assignment and recording it in the land records. In that case, the capital provider may enforce a C-PACE lien according to the terms of the loan documents. The loan documents are going to include like the C-PACE lien certificate, which is the recorded document, as well as the program agreement, which is what is the tri-party. So in the tri-party program agreement from Loudoun, and I keep saying tri-party because I just want to be clear that it has the three parties involved. The first section that really talks about enforcement is section 2. And basically they're saying that the borrower defaults, the county will enforce on behalf of the capital provider for their benefit, but allows for, similar to the ordinance, for the capital provider to do that enforcement. Then further, it talks about if there's a default for the borrower, the county will enforce, but it does agree to cooperate if the capital provider is doing it. If the county is doing it, the capital provider agrees to cooperate with the county in enforcement of the lien by providing the documents. So it also says that in this case, it's saying we're gonna enforce, and I'm gonna certainly leave it up to Teresa to respond if she wants to, but we're saying the capital provider must obviously comply with the county in that process. And in that document, I think it's leaving open the idea of how, if the capital provider is assigned the rights to enforce, that's something that has to be then further discussed. So part of me, I think, wants to clarify that process. Roanoke also has enforcement, and in this particular one, they've agreed to enforce a lien, and they're also expecting the capital provider to obviously comply with what they need, and they are going to enforce it just like the real property taxes. And in the Roanoke one, there's really not the option for the capital provider to do it, but it's something that I don't think would be a problem for this other program agreement type. It's really, that's not the point. It's not really to show you the different program agreement types, just to show you what's in the state and local code per enforcement, what the language actually says. That's really the point of this. It's in the documents you have. So with that in mind, I wanted to ask, first of all, does anyone have a comment about, I've heard this from different capital providers. Most, I think, prefer the locality to enforce exclusively, but not necessarily. So I really want to get some clarity on this. Do you think that the locality should be solely responsible for enforcement? And if you agree with that, please explain. I guess if you don't agree with that, also explain. So I'm going to open it up now.
So Abby, this is Andy Friedman again. And as a local government, as an employee, we actually placed liens that were local government liens on property and dealt with the collection process, at least in Virginia Beach. And in Virginia Beach, it was the city treasurer who had the authority regarding collecting taxes. That's who collects the taxes. And when we went to them with a lien that was not being paid, their first action would be to initiate collection, not a foreclosure sale or anything like that. And that collection process could result at the treasurer's discretion in that payment agreement, or at the treasurer's discretion in a sale. But that they have a very significant amount of discretion in this process. The local government is not a singular entity, and the city council has no authority to compel the treasurer to do this stuff. So I think it's way more complex to say that localities will enforce, because the treasurers are constitutional officials that have no boss in local government.
Right. Yeah, well, we
And
special.
so this is way more than the local government will enforce. It's going to vary from county to city and from person to person. And I think that needs a lot more investigation. I'd be happy to hear from an attorney, but that's my direct experience with enforcement of liens.
Thank you, Andy. That's very valuable feedback.
I do believe David Schaefer, did you want to add something as well? And then I have Nicholas Zuba.
Well, sure. Of course, I'm not a Virginia attorney, but the issue that comes up in virtually every jurisdiction that has a statutory scheme in its PACE Act to suggest that assignees can enforce the PACE lien, run into the same fundamental issue that I put in my comment, and that is, does anybody other than the officials designated under state law, however it is so designated, actually have the authority to enforce those liens? Putting that in the PACE Act is almost like an academic exercise, because for the last 200 and something years, every state has a whole regime of how property taxes are assessed and collected. And just throwing this into the PACE Act, we have found in and of itself is of no particular consequence. So it's a little bit presumptuous to start off with the position of, what are we going to put in the ordinance? What are we going to put in the assessment contract? That's not the starting point. The starting point is, what does state law, whatever the municipal law code section provides in terms of enforceability of assessments and real estate taxes. And just to give us an example in a completely different jurisdiction, New York State had a regime where real estate taxes were collectible only at the county level, but it was discretionary. And I think this is similar to what Andrew's point was just a moment ago, as to whether or not those real estate taxes would be enforceable. And so the issue became, well, you can't force the county to collect a tax that it has discretion to enforce. You can't put into an act, a statute, that you can get a writ of mandamus to enforce somebody to do something that they don't otherwise have an obligation to enforce. And so they changed the PACE law to provide that the lien of the PACE assessment was subordinate to taxes, and thereby making it assignable to a private party. So, the analysis here is, and I'm not a Virginia state lawyer, and I haven't gone into the Virginia state laws, but I know from New York State and a variety of other jurisdictions that the starting point can't be what's in the PACE Act, what is in the ordinance, and what is in the agreements. The starting point has to be, what does Virginia state law provide? And starting at that point, if it's workable, then what does the ordinance and the contract need to say in order to comport with that? And if that's acceptable to the capital markets, great. And if it's not, then that's where you need to go. you need to go back to those provisions of the Virginia state statute to figure out how you make the PACE lien enforceable in a manner that is going to be acceptable to the capital markets.
Thank you, David. Bill, do you have any comments on that since you're a Virginia lawyer?
There we go. Not really. I mean, it's a thought-provoking analysis by David, certainly. I mean, certainly Virginia treasurers have been collecting real estate taxes, both by lawsuit as well as ultimately by property sale for decades, if not centuries. But I would need to, excuse me. It's been probably 20 years since I was involved for a brief time helping treasurers in conducting tax sales for them. And so, I as to the discretion question that David raises, I'm not so sure that, I mean, it's not an issue that I've heard broached before in Virginia, but I'm not a member of the local government attorneys association or not currently involved in helping treasurers collect. So I can't vouch for it.
Is Teresa still on?
Yeah, I'm sorry, but just to be clear, my point is putting in the PACE Act the fact that an assessment lien could be assigned to a capital provider and thereby giving them the right to enforce is a wholly different question as to whether or not the county treasurer will enforce an assessment lien that is included in the tax roll. It's a narrow point. I'll take it at face value that if you put an assessment lien on the tax roll, that the county treasurer will enforce it like any other lien that is included on the tax roll. My point was to make a permissive provision that you can assign that right to a third party and have them enforce it, I think is a matter of state law and not an ordinance or a contract.
Well, the good news is on that point is we do have an Attorney General's opinion from the Attorney General of Virginia, which is not of the same weight as it being in the Virginia Code, of course, but that the Arlington Ordinance, which was where the assignment to a capital provider first surfaced in Virginia, was the subject of an inquiry from a member of the General Assembly to the Attorney General's office, and the AG's office concluded that it was assignable. So that's the basis that those localities that have wanted to go that route have relied upon at this point.
Is Kelly on? Because I wanted to bring her on with a discussion about
Teresa Fontana just
Teresa. Okay, sure.
said chat. She wanted to discuss that.
Okay, yeah, please go ahead, Teresa.
Well,
Let's go to Nicholas Zuba first.
Thank you.
Great, thank you so much, and good afternoon, Abby, and a happy New Year.
Okay.
So yeah, pretty good. Just for everyone's edification, this is Nick Zuba from Clean Fund. So I think I'll start off with a general comment to say that I would be in support of the private capital provider being able to enforce a PACE lien in events of the default and foreclosure, because we've been seeing out more in the greater PACE market a greater reticence on the part of tax collectors and county treasurers wanting to do the enforcement. We're seeing a lot more resistance that they should be compelled, whether it is by state law or not, in this case, to be taking the responsibility to do the enforcement of these CPACE liens in the event of foreclosure. So in light of that, if anything that we can do to take as much of that responsibility out of the hands then of those tax collectors or county treasurers, I think we would want to do so and have it just in our responsibility. But to like David's point though before, and I'll echo this as well. I mean, because it would be nice to have had that in another part of the Virginia State Code, that this can be a delegable responsibility to a third party or a designee of, say, the local tax collector or county treasurer type in this case. Because I think, right, just then maybe put it then into the state CPACE law. I don't know that it is going to have as much weight then, to say that it's a delegable responsibility. If, say, another part of the state law doesn't say that, that really can be done and can really be, something that can be, in fact, be operationalized than, say, in these other contexts. So, I certainly, if there is some kind of a way, or if there is, that Attorney General's opinion can provide the necessary weight in lieu of not having basically anything in other parts of state statute to say that this can be done. I think, it would be nice to see if it can be tried to be done, but I think too that yes, something has to be made clearer than in the CPACE statute at the state level, that this is something that can be a delegable responsibility to the capital provider. Because then also too, the other thing of issue, which we've seen in another state, I won't name it, but there's something in another state where if, say, even too, the capital provider has the opportunity to enforce, do much of that process in this case, sometimes what can happen is that we can get then tripped up at the very end, in which case then, say, the tax collector has to then have the responsibility then to finish out the enforcement process, and they still got a responsibility in it, just to be able then to finish, say, a foreclosure sale, if it's going to go through a tax foreclosure process. So that's also something that has to be looked at. Do they have to be the ones to do say, an issuance of a tax deed or completion of basically the tax foreclosure process? Do they still have to be involved with that, or can that also be a delegable responsibility to a capital provider or a designee? So there's also these other sort of, kind of logistical and operational questions that are also, I think, important in what we've been seeing in other jurisdictions across the country. But just on the whole, I am certainly in support of trying to find a way to see if private enforcement can occur, and two, just really see how well could that be operationalized in the Virginia context.
Thank you, Nick. And so in your opinion, in terms of for you to securitize the PACE loans, it's more the clarity of how it actually is enforced versus who's enforcing it? Or is that the wrong question?
Well, I think, it's been shown that I think, if say a private capital provider can do billings and collections and that they can do enforcement, I think it's still been shown to see that it's okay from an enforceability, from a securitization standpoint, that I think it still can seem to be good quality credit that, you'll get a favorable bond rating in this case, for then doing the securitization of that particular, this particular grouping of assets in this case, if you're going to do a securitization. I don't think that that's really seemed to be a problem anymore, because I think you still got, obviously, the security of the lien going against the property. That's still in place, irrespective of who the collecting agent is or then who the enforcing agent is. I think that still does reign as being more the supreme issue in this case. That can, in fact, I think, be okay then when looking at it from a securitization standpoint.
Okay, thanks.
Abby?
Teresa?
Yeah, I just want to mention two things. Well, first of all, the CPACE statute, I think, could be much, much clearer. But regardless, it only says that the county may or the locality may enforce this. So there has to be, obviously, this is a loan to somebody. There has to be a means of enforcement, even if the county doesn't want to enforce it. Why would anyone loan money to somebody that they can't get back if the person defaults, right? So in our statute, the alternative is that the lender can enforce their lien or their loan in accordance with the terms of the loan documents, not necessarily as a real estate tax. The county can do it in that method, but clearly the lender should be able to enforce their loan. Now, remember, when we enter into these things, we're under our code, everybody has to subordinate. I mean, all the existing liens have to be subordinated to this loan, right? And we have to get approval from the other lien holders on the property to subordinate their liens. Correct, Abby?
Yes, that's correct. Mhm.
Right. So now, I mean, this lender already has a superior lien. So, I mean, why would could the lender not enforce their loan if the county chooses not to? I mean, I guess this needs to be cleared up because this is something we struggled with at Loudoun. I mean, we realized that, you know, we're a Dillon rule state and it's saying we can enforce these things like real estate taxes, but it only says may. And then what if we don't? I mean, what recourse do these lenders have? And why would they ever do a loan if they couldn't enforce it? So.
Yeah, very, no, I know, I feel like it's like Groundhog Day here, but a little bit trying to.
I mean, so we did the best we could with what we had. We tried to give the most assurance, say, listen, we're going to enforce these liens. I mean, and I'm not really sure how much discretion our treasurers have. I mean, to me, I mean, that's what they do. I mean, we enforce our real estate taxes. I think the minute we stop enforcing our real estate taxes or try to do it, you know, at someone's discretion, we get into a whole lot of trouble. So I don't think that's an issue for us at least. But I do think, and another reason we put in there that the lender could enforce it was because if it was ever found that this provision in the statute was, you know, unconstitutional or violated the Dillon rule or whatever, that, you know, the lender would have the recourse of being able to enforce this lien. I don't know. That was our thought. Is our provision good? I mean, I do understand. I mean, I actually wrote that opinion, that Attorney General opinion. It was a struggle.
I know. That's why I'm happy you're on this. Yeah.
I know. I mean, so I'm very familiar with the 2019 opinion, but it was only because, you know how those opinions go.
Yeah. I mean, one thing I will just interject. Thank you, Teresa, is that I certainly, at least the direct bill part, that's also an AG opinion. Didn't you also do that one? Or did someone else?
Which one was that?
Direct bill that the capital providers can bill and collect. I think that's another one, AG opinion.
Yeah.
And I added that to the potential comments for this session, which who knows what will happen. But I thought, you know, AG opinions are great. I think for Bill's point, your point, but they're not the same as being in the statute necessarily. Not, they could wait, but maybe not. It'd be better to be in the statute, you know?
Yeah, I think, I mean, I thought one of the main, I mean, we have to get back to the whole purpose of CPACE, right? I mean, what is it? I mean, why can't lenders just go out and do these loans without any kind of government involvement? I mean, why are we even involved in this? And then, I mean, I thought really one of the purposes was to have this extra security maybe for this loan, you know, that they'll enforce it. I mean, what other?
Well, I'm also wondering, and let me get other people, you know, one thing is I see that there's been a kind of a shift over since you even passed your ordinance and developed this program. But I'm also thinking if it's going to be a locality program or even a state program, we're saying here's something that complies. This project is a good project. It has met the requirements of the guide and, you know, and certainly the ordinance that all these localities have adopted. Does that raise an issue if the capital provider is solely responsible for enforcement? Does that have any impact on local government in terms of being negatively impacted by something the capital provider might do with respect to being involved in the program or having signing on the agreement? Is there any risk to the locality if that's done that way? Maybe not.
Well, no, I mean, I think in our agreement, don't we have an indemnification agreement?
Yeah,
provision, something like that. I think, you know, I think the whole purpose is trying to facilitate these loans, right? We want these, you know, energy and resiliency and projects to happen. You know, what can we do to help that along? I think the enforcement was a key component to that, but in Virginia, you know, Dillon rule is really an issue, and the way we're structured is really an issue with regards to the enforcement. I know in Loudoun that, you know, we would do everything we could to enforce it, but you know, who knows if somebody was going to challenge that, where that would come down in a court, right? As to whether we even have the ability to do that. Because it really isn't, I mean, these voluntary assessment liens, it really, I mean, obviously I've only been in Virginia about 10 years, but I really haven't seen a whole lot of voluntary assessment liens placed on property. This is kind of a beast unto itself. I mean, there's, that is another issue. I mean, these people are agreeing that we're going to be able to enforce this, right? I mean, they're consenting to that. The parties are consenting in this tri-party agreement. I mean, it's a contract issue. Like, they're consenting to allow the lender to enforce this loan, right? If it's in the loan documents and somebody signs it and says, I'm borrowing this money and you can enforce it, who are we to say that they can't, that the lender can't, right?
Yeah, agreed.
And I think our loan documents provide for an assignment.
They do, yeah.
So whether, I mean, this, at the end of the day, this isn't really our lien. We're just putting the enforcement mechanism on it. This is really the lender's lien. This is their money. They gave it to this person and they're entitled to be paid back.
Yeah.
So somebody has to be able to enforce it.
Totally agree. Nikia, who's next?
Michael Yackee has another comment.
And then Kelly, right? I think.
Yes, and then Kelly.
I think I may have totally lost my train of thought by now. No, what's interesting, what Teresa was saying is really sort of clear. And Teresa, just so you don't feel that we're hanging you guys out to dry. What's important is that why PACE is important and why we need the counties is that we are essentially mimicking your public finance backbone. That's what Wall Street looks at. That's what the capital markets look at. The fact that it is a government assessment on property with the security and priority that comes with that is the first principle by which PACE operates, because then we can access capital similarly as you would do in bond financing at lower interest rates over long periods of time, with the fact that these are non-extinguishing, non-accelerating things, and that's why we need you. If you try and go into the private market, you will not find low interest, long-term, non-accelerating, non-extinguishing liens on property. That's the province of local government, and that's what we're borrowing off of. But to sort of echo sort of things that were said before by David and Nick and others, the clear pathway to enforcement, while hypothetical for most of us, is still a necessary requirement. And as someone who's written a fair number of PACE laws across the country, one of the first things that we all do is we take a look at how exactly are taxes enforced. And as Nick said, we find more and more that when you talk with treasurers and others, when they find out how CPACE works, in that it remains on the property at a foreclosure sale, their eyes start to either glaze over or they start to get a little crazy. So we have deliberately put in a lot of new statutes language that says that we can foreclose in the manner of a deed of trust or mortgage under direct billing, collection, and enforcement provisions. I think the concern for Virginia is that because it is a Dillon rule state, simply saying may does not necessarily create a shall in terms of being able to provide that other pathway, notwithstanding the Attorney General's opinion. And the one thing I would say is that with regard to Arlington, it's based on a lien that is not signed by the local government. And so I wonder how much the facts of that may have influenced the opinion, or could be used by someone later in the office who is not Teresa to have.
She's Loudon.
Yeah, I know. Well, whoever the person was who spoke before.
We have shall.
Wrote it.
Ours says shall.
But the person who is next in the AG's office could use that to distinguish it and then undercut what was said before if someone decided to, some ne'er-do-well borrower decided to challenge the enforcement process. So I would say that capital providers would be much more comfortable sort of being strictly following the Dillon rule and having local enforcement if it's because that's what the statute tends to say. And if you can amend the statute to provide a direct route of enforcement via in the manner of a foreclosure of a deed of trust or mortgage, that would be fine. The only other thing I would think of is that if the assignment language is very loaded, and by that I would say look at the Connecticut statute language, where the assignment essentially in the statute, but you could by agreement possibly give the person the right to enforce with the same rights and responsibilities as the local government in terms of the lien priority, blah, blah, just to button all that up and make it really, really clear. I mean, I haven't read all your documents. When we get around to doing a deal, I will, but those are the things I think we will be concerned about.
If you were just to have the capital provider enforce without the state statute clarifying that option, that possibility. Michael.
Yeah, the statute should say that. I mean, and I know Abby's working on revisions, but we need to make it clear in the statute, because the Dillon rule, I mean, the legislature dictates what localities can and cannot do. So if it's in the statute that we can do something, we've satisfied the Dillon rule, right? So there you go. That's all we need. Just clarity.
Yeah. All right. Well, fingers crossed. We have time to still make some changes. So thank you. Thank you so much, Michael, too, and Teresa. And is Kelly next? I think. Kelly.
Hi, thanks. This is Kelly Ifberg with Twain Financial. Mostly, I think, echoing what Michael just said. Twain looked into doing just over the past few months, pretty good size PACE project with Alexandria. So kind of went down this rabbit hole, I guess is maybe the best way to describe it. Then, and Alexandria has its own ordinance. It's different than a couple of the ones we've been discussing, somewhat modeled off of, I believe, Arlington, but they actually have some conflicting language about, okay, we are assigning the PACE lien and enforcement rights, but then there's also another sentence that says, well, we're reserving enforcement rights. So that was an issue for us there. But even if we were looking at, I think, ordinances like the ones we've been discussing today that doesn't have that conflicting reservation language, what Dwayne was running into, again, is what I think Michael and some others have identified is, okay, the Virginia statute says may enforce, right? And it identifies one type of enforcement remedy, which is, again, basically similar to a tax sale, like the municipality does for property tax liens. So I think we read that as there's only one enforcement mechanism, again, tax sale foreclosure. And I think even if you assign the right to an enforcement, if the municipality assigns all enforcement rights to a capital provider, what we were running into is what Michael was just saying. Well, what's the procedure? What does that look like? Because I think most of us on this call understand that, when you're having a tax sale foreclosure, lots of different arms or parties of the local municipality need to be involved in that process. And when we tried to talk to Alexandria about, well, what does this look like? How do we do this without your help or assistance? For instance, a tax foreclosure sale, if the sheriff's calling it, what that looks like, they just didn't want to assist. They just don't want anything to do with enforcement, which is certainly their prerogative. But we've, as the capital provider, found ourselves stuck. We couldn't do it. There's nothing in the statute to authorize a judicial or non-judicial foreclosure. Again, our read was our only remedy is or similar to a tax sale foreclosure. But then if you don't have a municipality clearly outlining what that would look like, where they will assist the capital provider, we just couldn't get comfortable we'd be able to enforce our assessment lien. So just some things to keep in mind. Again, sounds like maybe we can have some clarity added, hopefully at the state level at some point. But for now, with the ordinances, I think we would like to see that the municipalities will enforce, or for some reason they're giving capital provider the ability to do so, then I think hopefully we'll find more cities or municipalities willing to kind of be cooperative with us on that process. And we would want to know what that process looks like before we would do PACE financing our project in that municipality.
Thanks, Kelly. So in your opinion, if the process were, if you said local governments were going to enforce, but you could assign it, would you feel like if that process were laid out more clearly, the interaction between the local government and the capital provider, then you would be more comfortable in financing in the state?
Yeah. Yeah, that's right. And then I think, again, just the understanding and the municipalities' willingness to the extent they need to be involved, then I think we'd want to see the shall language there in that process, right?
Yeah.
If it, for instance, sheriff shows up and delivers whatever notice or hearing, then, and that's required under, the tax sale foreclosure process in that municipality, then we wouldn't want that to be optional.
Yeah, Abby, this is Michael. That's an important point, because it's one thing to sort of say this is the process, but if the people in the process have not bought in and signed off on this, because tax foreclosures follow a very rigid procedural formula, because the state is essentially trying to take personal property, and because it is at its basis a taking, you create a very due process oriented thing. For us to simply mimic it may not be enough. It would have to be, even if we wanted to try and mimic it, there are still things. But who issues the notice? Who issues the deed? Those are questions that we would be pondering and would need clarity, even in the face of a clearer assignment. If the parties who are part of that process are not in agreement with their participation, we might still refuse to close a deal under those circumstances.
Yeah, Michael, that's exactly right. And that's what we ran into. Twain did with Alexandria, that, again, they're whoever's involved right now, and when they passed the program, their take was, we'll do this, but again, they just don't want to be involved in enforcement. So for us as a capital provider, we were, unable to proceed.
Can I just chime in? I mean, I want to give Teresa some credit for understanding the big picture here, and that, I think my work in Pennsylvania with standing up the Pennsylvania program is jurisdictions get caught up on this enforcement piece, and they don't understand that, we're talking about in many of these counties and many of these jurisdictions, what's going to equate to one project a year. It's not 300 properties that are going to have, a CPACE assessment. So, I think their fear, while justified, and we don't want to get caught up in enforcement, is a little skewed, because the volume of projects in most of these jurisdictions, this isn't going to be, it's going to be one-offs. And then if that one-off goes to a foreclosure process, it's kind of getting caught up in the worst case scenario when it's, the numbers are against that. So, and I want to give Teresa credit for kind of acknowledging that, yeah, there is a key role of local government, kind of, you could say the backbone of CPACE is the government involvement. And there is definite benefit to it. There's a reason the government should take on that extra risk of responsibility and enforcement. So, I think as we roll out a statewide program in Virginia, kind of framing the local government conversation around, what is the volume to expect, and what is the likelihood of a foreclosure, as then we talk about, how it happens.
Absolutely. I appreciate that context. But yeah, it's not like it's going to be, it's not a residential based program. I mean, that's another can of worms that would change, the conversation. This is a very limited issue, most likely, in terms of what would actually be required of the local government from an enforcement standpoint. Let's see, Andy, do you, first, well, I'm sorry, this is you, Nikki. You should, I think, are we at Andy Brownstein right now?
Yes, I have it. Yes, Andy Brownstein. I know you made a comment. Did you want to add to that?
He's a Virginia attorney, by the way, as well.
Okay, maybe he's not on. What about Andy Bridge? You made a comment as well. Did you want to add to your comment?
I just want to add that I think Kelly hit it right on the head there. It's really about the process, and the more that it can be. I don't know if the right word is cookie cutter, but the more that it could be with municipalities. Cookie cutter, the more that the community banks, local banks, and things like that would get involved. Banks are not very quick to give up their rights to collect their money. We love to lend it, but we like to get it back. So I think that the process needs to be, more cookie cuttered in order to make capital providers and banks comfortable in doing this. If we're going from Loudoun County to Fairfax County and Roanoke, and everything's different. One is going to be expensive for the borrower, and two is just going to slow down the growth of pace. So the more standardized we can get, the better off we're going to be, and that includes who can collect.
I mean, that is the heart of the problem. Or the importance issue, the issue of importance, Andy. So thank you for that. I mean, I think one reason why it's been slow to have an uptake is that we have all these different kind of conflicting messages in different localities. So most of them, I would say, that we manage have piggybacked off of Loudoun contract, but also the Loudoun ordinance for the most part. But is there any more comments? Because I just have another question before we move on to open discussion. Okay, David Schaefer.
David.
Yeah, thanks. So, I think one of the things that maybe gets lost in the conversation here, and everybody who's been commenting is talking from their experiences and in different jurisdictions. So let me just to reframe the question. Let me use a jurisdiction like Florida as an example. The law is really clear in Florida that a PACE lien is a special assessment that gets added to the property tax bill with all the other taxes and special assessments in that particular jurisdiction. And if the property owner does not pay its taxes in full, within the prescribed period of time, there's a tax sale or a tax certificate sale, and presumably, as it has always been the case, the tax certificate is sold, and the property taxes and assessments are collected and dispersed to the various parties who are entitled to it. And there's no mechanic for a capital provider or anybody else to enforce their lien, because there is a solid statutory framework for the billing, collecting, and enforcement of the tax lien. And it works, and everybody's very comfortable with that, and there's no issue. Every time you add a permutation for how something could be done outside of the prescribed statutory framework, there's sort of a ripple effect as to how that affects other statutes to do this. So, you know, again, I'm not the Virginia lawyer, so I don't fully understand the entire billing, collecting, and enforcement scheme in the state of Virginia. But if you're going to start to create special rules for capital providers to enforce the lien, it can't just be in the PACE Act. To say that we can strip off the PACE lien and enforce it like it's a mortgage is all well and good if you state that in the PACE Act statute. But if the statutory laws of the state of Virginia do not contemplate that PACE liens are equivalent to a mortgage that can be foreclosed upon the way a mortgage or a deed of trust can be foreclosed upon, you're going to find yourself in court with some savvy, lawyer who's representing the property owner. Right? We're not talking about some residential tax lien, right? There's tens of millions of dollars involved. Someone's going to raise their hand and say, wait a second, Your Honor, there's nothing in the Virginia state law that enables a PACE lien to foreclose a property, foreclose on a property under the mortgage laws. Then you have to go back to the tax collector. I want this case dismissed. And it's that ambiguity, it is that uncertainty that is disruptive to the capital markets and the other funding sources that make this all happen. Yeah. So that's really simply my point, is that you have to look at the Virginia law in its totality, and the simplest answer is, I think, is, the assessment should be added to the tax bill like every other special assessment or tax. It should be collected in accordance, assuming it's mandatory to collect and enforce taxes and assessments in the state of Virginia, like every other assessment and tax. And that would make the issue of assigning the lien to the capital provider moot, because it's not necessary. There's a well-defined process by which the capital provider can be assured that if the property owner does not pay its taxes, a collection process will ensue, and it will continue to its logical conclusion, and either the property owner will redeem it and make the payments, or the property will be foreclosed upon, and the payments will be made to the tax collector. And I know it's more complicated than that, but that is fundamentally the issue.
Yeah, and I know we're different than Florida, and I remember thinking at the time years ago that Virginia is going to be more complicated because we don't have that as Teresa also
understood completely.
System, yeah. Teresa also brought up a point that I think that she and I had discussed, and I it's kind of for the last question there. Is there a way, in anyone's opinion, we don't have that much more time because we would like to move on to any other open discussion items, but is there any, have you seen anywhere else the possibility for the state government to be helpful in the process of enforcement, or is that kind of a moot point for what David's saying about, the needs of just having one clear process? Does anyone have any quick comments on that? We can always follow up by email or further.
I don't know if it's my place, but I'll just chime in to say that.
You're always your place. You're part of the team, right?
Having state leadership, I think, is really important, especially if that comes with we've looked at the state statutes. We've looked at the Virginia state code regarding tax collection. This is where this program sits within those pieces of legislation and code. And as a municipality who wants to adopt this, you have to understand this is your role and responsibility. This is the benefit. This is the program. This is what it can bring. But kind of having the state involved in saying and framing that conversation, I think, can be very powerful, because it does kind of then alleviate some of this. What I found was that when you get to local government, there's varying levels of knowledge of their own code and legislation that they work with under. So I think just kind of coming in with a little bit of, as the expert, as the state with the knowledge of the state statutes, I think is going to be helpful. helpful to getting the program launched statewide more. Yeah.
I'm just hopeful we can get to a point where we can do centralized information and process, because we do have counties and cities at different timeframes for sure. So I'll defer to the Virginia attorneys about maybe another call or follow up to this, because obviously this is extremely important to making our program work, understanding the best way forward today, and knowing that we have a statute that none of us created, that we're trying to clean up, and maybe we'll get it cleaned up and improved this session, maybe we won't. So how do we make this program viable, the most viable possible now? So any other comments about, and I think your points were great, Holly, any other comments about the state's role in this process that could be helpful? I can't see anyone. So Nakia, anyone else? Okay. All right. Well, obviously, I appreciate everyone's comments and the context from which they're coming, and we'll probably be reaching out to follow up as we move forward. We definitely want to. This is the opportunity we have to not have to go locality by locality and really try to figure out the best way forward and make sure that you all are all comfortable with doing loans in the program in Virginia. Nikia, you want to go ahead with the open discussion? We don't have that much time left, but we had some general questions we thought.
Yeah, I can. Definitely. So the first question we'd like to ask is, for those of you who are familiar with the Virginia market, are there any areas in which you have had issues that would be relevant to designing the statewide program?
Other than enforcement, we discussed that for an hour and a half.
Feel free to chat or just unmute yourself if you'd like to answer.
And I'm thinking about Kelly, Michael, maybe Kevin, anyone who's looked at deals, Mike Billingsley, I'm not sure he's on today from Greenworks or from Nuveen Green, but anyone who's looked at projects. Andy Bridge, anyone?
Abby, it's Andy Bridge. Basically, I go back to the same issue, and that is each municipality has different rules, and it's difficult to navigate each rule. I know District Columbia is much smaller place, but their PACE collection and the laws in which they do it are very similar to what David was saying in Florida. I think they actually modeled it after Florida. So it's not just about the collection or foreclosure or anything like that. It also has to do with payments, how often you have to deal with this and everything. And if you can just standardize it, it'd be much easier for the capital providers, much easier for the banks, so that we know exactly what we're dealing with. Maryland's starting to get in the same way. The counties are doing different things, and so it's difficult to keep it all straight. And it would be much easier to standardize if we could, one way or another, whether the counties are going to collect or they're not going to collect or whatever way. But it's much easier in DC to do this PACE because we know exactly the way the government's going to act.
Amen to that. So getting that done. Thank you, Andy. Anyone else have a comment on that?
Alrighty, next question. In your experience, what are the pain points in programs that you've dealt with in the past?
That would be relevant for our Virginia program. No pain points? I can't see the screen.
No one's
We've already discussed it, maybe we've discussed it.
No problem. I'll move on to the next question. What are key characteristics of a state program that capital providers look for when deciding to invest resources in a project origination?
We know, I'm just going to put it there if anyone responds, that we know obviously consistency is going to be key. But is there anything else that you all, when you're doing your kind of checklist of what states to invest time in, just like Nakia said, anything come to mind? I know it's been a long meeting. Come on.
I mean, Kelly, I have maybe just one minor point, but one thing I think that you're already planning on doing and that I have found helpful is when the program publishes guidelines, and then we kind of know what the requirements and the expectations are. I'm not going to call any states out, but there's one I can think of that doesn't have a comprehensive set of guidelines posted or published, and then we sometimes tend to find ourselves surprised with asks that are made. So glad to see that we are looking at having a set of guidelines for this statewide program.
Awesome.
Thank you, Kelly.
The next question, do stakeholders have opinions on how the state program will or could impact the role of local government?
That's more for our local government friends on the call, I'd say. But it could be for anyone, but. Teresa, do you have anything to say since you're on? I don't know who other local government, or Andy, or Bill Egger, if he's still on.
So Abby, this is Andy Friedman. My experience is if there's a uniform statewide program, it just makes the local government's job easier, because we can always point to the state program and say, well, that gives us assurance that everything's good. If the statewide program, the whole, stands up, then ours can be, we don't have to worry about it. And certainly city attorneys can look at the existence of that and say, okay, good, we can do that.
So you see that would trump any kind of proprietary desire to have your own program, at least in your experience in Virginia Beach.
Well, I guess, it depends on, as whatever the law, the statute allows, you could vary from the statewide program, but the basic kind of the baseline of a state program makes everything much easier to be assured that you're doing the right thing. I don't think it would really be in conflict.
Thank you.
Let's see, David Schaefer made a comment stating certainty and timeliness of execution at all levels. Program admin and municipality is most important. David, did you want to add to that, Schaefer?
Sure, happy to just editorialize a little bit. I guess there's probably plenty of people on this call who had their own, version of horror stories. But going back to the beginning of the conversation where we were talking about simplifying documents and so on and so forth, part and parcel of that is if the project is approved and the documents are approved, the expectation in the marketplace is like, okay, well, then we're going to get the contract signed tomorrow, right? Or the day after. And then you find out that, well, the mayor only signs contracts on, alternate Tuesdays in even months. And so, I'm being glib, but, that's one of the issues that all of these PACE programs have, is that, can you really get to the point where there is a process and a timeliness within that process that things will happen in the time frame that they're supposed to have? Because real estate finance projects are always challenging, and people want to know that if they go through this process, what to expect. There won't be surprises, and when the I's are dotted and the T's are crossed, that they can close, in what they would normally expect to be in a commercial manner. And and that's going to be an issue, because all PACE providers have, financing sources and securitization vehicles and things of that nature, which are accustomed to operating, in accordance with a marketplace where these things do happen fairly quickly and in a timely manner based on, market expectations. And PACE programs, the more they get involved in municipalities and county processes, get bogged down, or program administrators who, good intentions notwithstanding, may not have the resources to respond promptly. And those are the issues. So, water seeks its own level. Jurisdictions and programs that are able to respond to those exigencies are the ones where you see the most volume and the most execution. And those programs that don't tend not to see as much activity.
Let me ask a question thank you, David, based on what you just said. So not sure, the role of the state program is obviously to a concise set of documents that will then be, allow for localities to opt into that program. If it were feasible, and I'm putting it out there, I'm not sure it is at this point, because we'd have to look into it. If we could, as the administrator on behalf of Virginia Energy, or if our entity could act as like that kind of final decision maker at the local level. Have you foreseen that, number one, and would that help? Like, is both versus, we don't have the elected board looking at it, but I think like in Wisconsin, there's a commission that runs most of the state and they approve deal by deal, but at least it's one commission, I think, approving it. Am I correct, Holly,
Right.
on that? Or David?
Yeah, I mean, putting aside the commission for a second is that, sure, if you could represent to the marketplace that, we have a statewide, sponsored program, and, once we approve your deal, and you satisfy all the other conditions to that transaction, we will sign the documents and record it. We don't have to go back to the county or the municipality, get it signed, whatever. We have power of attorney, or we have agency authority, or whatever the legal construct is. I think that goes a long, long way to creating certainty of execution, because that has been an issue in multiple jurisdictions. As the program administrator does a great job, and then they send the documents over to the city or county to sign, and they sit there. And then 3 weeks later, the county attorney calls up and says, you know what, I'm not sure I understand this. Can I get some backup information? And by that point, people want to shoot each other.
Yeah.
I'm not saying it happens all the time, but it does happen.
Yeah. And there's also a timeliness issue, if you're doing, you're trying to do simultaneous close, stuff like that,
Sure, because most projects of any consequence have other stakeholders. There are either senior lenders, or there's other financings involved, or equity, or whatever it is. And in commercial real estate finance, people are accustomed to having multi levels of the capital stack close contemporaneously, and none of them are based on when the next city council meeting is.
Exactly. Someone else was saying something.
This is Bill Nussbaum. David, I've got great respect for your analysis. I am deeply concerned, though, about what how making the statutory modifications to the Virginia PACE statute would be received by local governments, and the challenges that would entail getting it through the General Assembly. I could really see it sinking the other modifications that Abby is looking at, trying to get through the General Assembly session that just started a little less than an hour ago today. Because I think the more you talk about localities surrendering their authority, the more problematic it's going to be to keep them on board about participating in a statewide program. It's a tug and a pull between the localities and the state especially in Virginia, but folks like Teresa Fontana can weigh in with their her unique perspective.
Yeah, I mean, I guess sort of the fundamental question is, and I appreciate that. I've been in the PACE industry now for about 7 years. When I made that leap from private practice into this industry, I recognized that dealing in the municipal world would be different qualitatively from my prior experiences. And I probably underestimated that by about 1,000-fold. So I appreciate what you're saying, but the fundamentals of PACE is that the cities and counties, the states, whatever, are all fundamentally a conduit to a financing program that brings private capital into their communities to provide capital either that is not available anywhere else or on terms that are far more beneficial than can be obtained anywhere else. And nobody is asking the state, the city, or the county to take on any responsibility or financial liability or not to be remunerated for whatever their exercise is. But basically, get out of the way and allow private capital to do what it does and comply with whatever the applicable law is. There's plenty of statutes that regulate what credit can be made available to consumers and others. And the marketplace enables private capital to provide capital providers to provide that capital in accordance with applicable state law whenever is necessary without getting involved in the process, right? State and local government does not get involved in whether or not a consumer takes out a mortgage or a credit card loan. So why do they need to be involved in PACE financing? But by injecting themselves into the process, they slow the wheels of financing. And at a point, people just say, you know what, it's just too painful. I'll go elsewhere. I mean, PACE is a great program. I believe that 7 years ago. I believe it today. And I'm not putting it all on state and local and other governments. There's plenty of other issues to go around, but it continues to confound me why state and local officials want to get involved in something that candidly is of no real concern to them, because if they want to be compensated for their efforts that are made, no one has an objection to that. They're indemnified 6 ways to Sunday. There's exculpation provisions 6 ways to Sunday. There's sovereign immunity in every state and local jurisdiction I've ever dealt with. And yet they continue to insist on being involved in something that once they pass the statute and the ordinance and the program, they should get out of the way and let the private markets deal with it. But that doesn't seem to be the case. Anyhow, I'm going to get off my soapbox now, but that's my point of view.
I was going to say, the problem is, I think every local government is going to agree with you. They don't want to be involved. That's the problem. The problem is we're being asked to be involved with enforcement, right? And to be, I mean, I don't know how many times I heard people saying, why are we even involved in this? Why can't they just go and make this loan program out there? Why do they need local government?
But they're really not, right? I mean, I don't know what your property tax bill looks like, but when I get my property tax bill, there are county taxes, there are school district taxes, there's the water district tax, there's the sewer district tax. There's a whole bunch of people who are taxing my property, and they're putting their taxes on the property tax bill. The PACE lien is just another tax. It's not being asked, no one is asking that lien to be treated any differently than any other lien. Just put it on the bill and collect it with all the other bills that are required to be collected and disperse it to me.
Yeah, you live in Florida, right?
Forget about the tax example.
I'm from Florida. I'm from Florida. I lived there most of my life. I totally understand what he's saying. He's used to the Florida system. That's exactly how it is there. It's not how it is in Virginia. I mean, you can't even enforce a tax lien in Virginia, you have to wait 2 years, right? For it to be delinquent, right? Before you can even enforce it.
I understand it, but the capital markets can deal with that. I mean, they could deal with it from an economic point of view. It's like, okay, I lend you $100, you fail to pay the $100, and if it takes me 2 years, 3 years, 4 years, 5 years to collect that money, okay, fine. There's interest, there's default interest, there's penalties, there's what have you. At the end of the day, I get my money, I get my yield, and it's secured by a super duper lien on the property. I can deal with all of that. It doesn't have to be a tax certificate state. I can handle, as a capital provider, I can handle 2, 3, 4, 5 years of collection. I would prefer, 90 days, but I can economically build into my model and into my deal with the property owner those issues. What I can't deal with is the uncertainty as to whether or not the lien is actually enforceable and that I can collect or foreclose on the property. That's the problem.
Totally
And if I can't get that certainty, I'm going someplace else.
Just like before anyone else, we are going to be coming up on 2 hours. Now, I'm happy to stay on longer to continue this conversation, but I just want, why don't we put a pin in that, and those who want to stay on after one can. But for those who have to leave, and I really appreciate the 2 hours almost you've been on with us, Bettina, do you want to just key up our next workshops, and then we'll stay on for anyone who wants to stay on? Does that sound good?
Yeah, that sounds great.
Stay on.
There's a lot to say. I think the only thing I'll say is thank you to everybody who is here. I think we certainly have our marching orders. If not, in some cases, some real consensus, which was encouraging to hear. And in some cases, we know what questions we really need to dig into that maybe weren't as crystal clear from before. So really appreciate that. As part of our next steps, we have 3 more workshops coming up over the next 3 Wednesdays. Similar in format to this, but just on different focus areas. Next week's is going to be on technical considerations, and then we're going to have 2 more on local government and equity considerations. The invitations for the technical and local government sessions have both gone out. The local government went out today. So if you are interested in attending those and you didn't get them, please just chat me or shoot me an email. We respect your time, so we haven't invited everybody to all of them, but appreciate your participation. And then I think to Kelly's question, I guess we kind of buried the lead, but with regard to the statewide program rollout, we are hoping to launch by Q2 after we've held these sessions, incorporated all of your input, and then gotten all the programs approved through our state approval process. So I think that's all I'll say. Yeah, and of course, contact us anytime. And I'm happy to stay on as well.
Yeah, that absolutely. Thanks a lot, Bettina, and thanks for everyone for being on. But for those of you who want to stay on a little bit longer, we can. I think we were on discussing. Basically, I think we're down to understanding clarity of the process with respect to making sure that the PACE loan is actually enforceable. And so I think David and I think Bill, you were going to comment, or Teresa, we're going to comment back to David Schaefer. So I don't know if David, Teresa, and Bill could stay on at least, but of course, anyone else who wants to stay on, please feel free.
Sure. I'll stay on. I'll stay on.
Thank you.
I was going to suggest that it sounds like, at least in the ideal world, that there's a connection between the ability for the statewide program to assume more of a role in enforcement, assisting in or enforcement, if there was also a corresponding and connected clarity on the question about assigning the lien to the capital provider. That if you knew, if localities knew that the lien, without a question, could be and would be assigned to the capital provider, then they would not be as concerned about surrendering the, ability to have their finger on the pulse of the transaction in any way, shape, or form. If they knew that there was no chance that it was going to boomerang back to them to enforce after somebody else has their fingerprints all over it and may have mucked up the careful statutory process that has to be followed for a tax sale, then they might be more, it might make them more comfortable. I see Teresa nodding her head.
Oh, yeah. I think you'd get a lot more buy-in on the program if the localities didn't have to enforce it. I mean, I don't think they care that if it's an assessment or not. They just don't want to. I mean, they'll be happy to, say that we'll treat, this is considered a special assessment or whatever. I mean, that could happen at the state level, but if somebody else had the import, because all of these things do impact localities, right? I mean, they're paying me today as they're, to attend this. There's administrative costs to localities. There's, if there is a default, there needs to be proper documentation in order to enforce it. I mean, all of this does impact localities and staff, because their legal staff usually enforces these, or they have to hire outside counsel to enforce tax sales, right? So, acting like this has no impact on a locality once the deal is done is not really true. I mean, there's cost to the locality for all of these programs.
Sure, and that would be fine. I mean, there's nothing, I think, objectionable about that approach from the capital provider's point of view. The earlier comments just really went to what is really a relatively legal and technical issues, is that simply reciting in a PACE statute that you can assign an assessment lien to a capital provider and they can enforce it is not in and of itself enough. Because when you then say, well, the PACE lien is just like any other assessment or special assessment, whatever the nomenclature is of a jurisdiction, and then you go to the municipal tax code and look at how tax liens are enforced in that particular jurisdiction, you find no basis or no mechanic for a private party to enforce what is otherwise a municipal lien. Okay, so now some statutes have said, okay, we get it, let's not do that. Instead, we'll say, okay, it can be enforced like a mortgage. Great. Then you go to the real estate property laws of that particular jurisdiction, and you see a whole bunch of stuff about how mortgages can be foreclosed upon, but a PACE lien is not a mortgage. It's not recorded like a mortgage. It's a tax lien. So, people who look at this stuff, it's mind numbing, but people who do look at this stuff said, well, okay, so what standing do we have under the applicable state law to enforce and foreclose on a piece of property that doesn't, with a document that doesn't otherwise satisfy the requirements of a mortgage? So if you want to, in effect, peel off the tax lien and say, okay, it has the status of a tax or assessment, but it's enforced and it's foreclosed upon like a mortgage, then you have to, it's not just enough to create a PACE statute, you have to amend your municipal tax code, and you have to amend your real estate property code and make all three pieces actually work together. Yeah. And that's getting really into the weeds. Most people obviously don't want to do, but that's what you have to do that. And like I said earlier, I gave the example of New York State, and the answer was no. There's no way we're going to the New York State legislature and suggesting that they're going to open up and make amendments to the New York mortgage mortgage laws. Not happening. No way, no how. So we found a creative way around it that worked in New York. Doesn't necessarily work everywhere, but my point is just putting a statement in the PACE Act is not the end of the story, and that when lawyers for the securitization vehicles and for the rating agencies and all of these other people dive into the weeds and say, okay, everybody says it's not going to happen, but if it does happen, how do we actually enforce this lien and foreclose? You wind up with a lot of putting square pegs into round holes, and when it becomes too painful, people just go someplace else. That's really all I'm saying.
Okay, thank you so much, David. I just, respecting the time, I do see that Sean was going to, I know, Bill, you have your hand raised, but I wanted to, Sean is the working with that City of Alexandria, so I did want him to weigh in before we get on too late, because I don't know how long people can stay on. I can stay on until literally 1:30, but I want Sean, if he has something to say, to be able to say it. And thank you, David, for those comments.
I will now restrain myself.
No, it's okay. I understand you care. We love that you care and you're helping us. No, please, we'll offline. We'll talk even more. Sean.
Yeah, he's actually preaching to the choir because we all agree. I mean, I mean, these are dilemmas. Abby. We talked about a lot of this stuff. I mean.
Sean, do you have anything you want to say?
Yeah, the only thing I was going to say is, one, it sounds like these answers are legislative in nature, not really either from the locality, lobbying the local city councils or county governments, or if you do it in one broad brush with the state can decide that this is going to be the way CPACE is going to work, and this is going to be the way it'll work for every locality, because all the localities are children of the state. We exist at the state's discretion. And the reason why I think localities, as a municipal attorney, the reason why we're invested or involved in this is because these liens are special tax liens. It's not just a regular mortgage. It's, it is flexing the power, the unique special authority of the locality to further a private capital response. And that's why the localities are, keenly aware of using their authority for this kind of project.
Bill, thank you, Sean.
Sure. I think that there are a couple of clarifications that hopefully, listening to David, that I think I can make. One is, Virginia being a Dillon rule state, localities don't have their there's no home rule in Virginia. Localities can't adopt their own municipal, mortgage rules or recording rules or tax codes, any of those things. So there's not the same degree of local autonomy that you see in a lot of other states. Lots of localities wish they had it. But it ain't going to happen as long as the General Assembly has a say about it. But I do think that that if the sections of the Virginia Code don't have no one title of the Virginia Code has priority over another title of the Virginia Code. And if a provision is inserted into section 15.2-958.3 that says, notwithstanding any other provision in the Virginia Code, that a CPACE special assessment lien may be assigned to a capital provider to enforce, and the capital provider may enforce it, essentially as if it were the treasurer of the locality, or I mean, I'm making it up on the fly here, but I mean, I don't think, that if you've provided that it's notwithstanding any other provision, that you necessarily are going to have to, go back, fixing a lot of ricochets back in other titles or other portions of Title 15.2. But I'm going to defer to Teresa there, more so, because she lives it every day.
Yeah, I think there's ways around it. I mean, I think what they're looking for is an explicit, procedure.
Right.
And I think that there is a way, but I think it would be great to have, input on that language for sure from the capital providers. If we go to amend the code, which I think it absolutely needs to be amended. And I know to make that clear, it can be assigned or whatever, and then what process they would follow, I think would be huge. I mean, the capital providers don't have a problem with enforcing it, right? So long as they know what the process is. So I mean, I think that's our out, especially with the state program, because if a locality opts into the program through some, mutual agreement between the state and the locality, and then at the end of the day, the capital provider enforces it, I mean, I think that's a huge win.
So Bill, I'm gonna take your lead on this.
Before you say any more, David, I think we're gonna, if you, Bill, and and me, and want to stay on, but I think we're gonna wrap it up for 1:15 just for the rest of the group. But I think we can go offline on a phone call if you want to send me your number.
Sure.
In the chat. Let's just have a call that way. But I think
Abby?
that
Michael.
Yeah, go, Michael. Yeah.
So just whatever you guys decide to do, make sure you loop me in on this thing.
What I was going to say is we have some changes we've suggested to a delegate who is going to be proposing this, is writing it up right now, the draft amendments. I've sent them to Teresa Fontana, but if you all like, we can work on them a little bit more, because I think we haven't gotten the draft back yet, and then send them out to those interested, the capital providers, to see if this is going to help. I get David's point that we're not going to get to the point where the statute solves everything, but also per Bill's point, we're a different state than Florida. So I think it would certainly, if we can get it in now, it'd be great. So are you all interested in having us share that language that we're trying to get through this session?
Yeah, it definitely needs to be work on it.
Sure.
Yeah, we need to work on it first. Yes, absolutely. Yeah. Okay. Thank you. All right. Well, why don't we end this call, and then David, do you want to